Hello, everybody, and welcome again to an episode of the Risk Matrix.
The Risk Matrix, roll tide. Happy New Year, everybody. Santa Claus done come see me. Roll tide.
Roll Tide. I'm Dr. Martin, and that's James Junkin over there. And we're here again with the Risk Matrix. Like I said, we're powered by Veriforce. And before we get started, we also have a guest here, but I'm going to let James introduce him. I'm going to let James roll us in with our sponsor for this episode.
This episode of the Risk Matrix, powered by Veriforce, is sponsored by XL Professional Driver Training. Poor visibility, weather, road conditions. They create unique driving challenges and hazards for new and seasoned drivers alike. So learn to drive safely in a variety of challenging conditions with the Joe Martin XL PDT training. Joe Martin is a professional driver and author of the driver's education book, XL Professional Driver Training. Joe's been a professional driver for over 35 years on various condition roads and hauled 22% grades in snow and ice and one-lane roads. Improve your professional driving skills by visiting XL, that's two L's, EXCELLPDT.net /Veriforce, xlpdt.net /Veriforce, and receive 5% off your winter driver safety training.
All right, James, let's introduce our guest.
I am so excited to introduce Brett Kellekamp, who is a shareholder and attorney at Ogletree Deacons. Brett and I have worked together on various cases throughout the years. He's a great friend, an expert in occupational safety and health legal issues. And welcome to the show, Brent. Happy New Year. You're in the Matrix, bro.
Well, thanks, James. Thanks, Dr. Martin, for having me. I'm really excited to be here today.
Thank you for coming. Now, part of my job outside of being on the chair of the Veriforce Strategic Advisory Board and Chief Executive Officer of the Editorial Review Board, Chief Executive Officer of Mariner Gulf Consulting and Services and chair of the Editorial Review Board for Professional Safety Journal, is to vote on the Article of the Year. And last year, the Article of the Year had to do with the legal aspects of occupational safety and health. Brent, you and I just got back from the OSHA Oil and Gas Conference down in Houston. All of the sessions hosted by counsel, by attorneys, your session, packed to the gills, standing room only, having to turn people away. Here's my first question to you. Why do you think safety professionals are so interested in the legal aspects of occupational safety and health?
I think some of the biggest reasons why safety professionals are so focused and so interested in this space is because of the dramatic impact that investigations can have on not only safety professionals, but also the companies that they're representing and the impacts that may happen to the extent that they don't have good legal advice or that they don't have a basic understanding of some of the potential legal ramifications that folks can get tangled up in if they don't have a good understanding as to what may happen in the future when OSHA gets involved.
So I think a lot of people kind of go into this, and I heard this early in my career, see if it's been similar to you, Dr. Martin, see if you've had this experience where people sort of go into an OSHA inspection for whatever reason triggered that inspection with the mindset of fear that the compliance officer is always right. We need to give OSHA everything they ask for. If we act reasonable and if we demonstrate that we care about safety, that maybe we're going to avoid citations. Is that the case? Has that been the experience?
And in my experience, I think OSHA folks that are doing investigations are, in most scenarios, are there just to do their job just like we are. And they're wanting to figure out what happened, just like safety professionals, just like lawyers are trying to do. So everyone's trying to do their job. But to your point, James, is you do not have to provide OSHA with everything they ask for. There's certain things that you have to provide them within 4 hours, right? So OSHA 300 logs, those are things that you're required to give them. But after that, when OSHA asks you for something in documentation, that's where the give and take starts, where I as the lawyer am trying to make sure that the investigator's scope is within the scope of the actual investigation itself. And so, to the extent that the investigator is attempting to create or ask for information that's outside the purpose of the investigation, that's where I'm going to step in and make sure that we're appropriately limited in scope, and that, quite frankly, that the company is not potentially opening themselves up to additional exposure by providing additional documents or saying things, quite frankly, that may create issues down the road.
I know that, and I'm going to invite Dr. Martin jump in here for a moment, because she's been doing this longer than I have, actually, and working with companies. And I'd just like you to comment, Dr. Martin, because you are a practitioner, you're also an educator. Do you think that perhaps some of the angst that safety professionals have in dealing with the legal aspects of occupational safety and health is, number one, it's a rare event for most companies. And number two, are we doing a good job preparing this generation and beyond safety professionals to deal with a government agency like OSHA?
So the answer to the second part of the question is no. I don't think we're preparing people. I think nobody expects to be in that situation until they are, right? And I just kind of got this thought in my mind of like comparing something to an unraveling sweater, right? You get a snag and it starts to unravel. And people don't really understand that if you don't fix the snag right away, that it's going to unravel to a point where you can't fix it, right? And so things unravel long before OSHA comes and does an inspection, right? And it starts to unravel long before we know that there's a problem, right? And so, I was going to jump in when Brent was talking, right after Brent was talking, and say, you said, this is where you come in as the attorney and say, no, that's beyond the scope of the investigation. That no, I think we've got to stop there and think about this. When should these professionals, organizations have you involved, right? And I'm guessing it's not after OSHA's been on site already. I'm guessing it's not when they receive the citation. Now it's time to call, phone a friend, right? Because I see that happen more often than not, right? People are like, oh, let's just see what happens. The citations come. They say, oh my goodness, I've got to do something in 15 days, and I have no idea what we've done for the last 15 years. So that's my question. Sorry to put it back on you, Brent, but when do they get you involved, and what's the process?
And you're absolutely right, Dr. Martin. There have been several scenarios that I've been involved in where it's been most likely on the back end, where citations are all already issued. And so we can do a lot of damage control on some things, but there's certain things that we cannot unwind. And so a couple of things: documents you've already provided to OSHA, interviews you've already participated in with OSHA, management level interviews where management has already bound the company with respect to certain statements, not having the opportunity to prepare folks for what can and can't happen during an OSHA interview, what their rights are. And so there are so many things that we cannot unravel. And some of those pieces we are stuck with. So once citations happen, we're stuck with certain facts. And so that's, to get back to your initial question, Dr. Martin, is when do you call a lawyer? And from my perspective, if this is a serious injury, if this is a scenario where you think OSHA may be involved, if this is a scenario where you have to report it to OSHA, I think your next call is to potentially a lawyer to set up the circumstances of, here's what happened, here's what we're anticipating, and what are your thoughts, and what makes the most sense for you to get involved. And I think to the extent that you are going to engage in an investigation concerning the cause and origin of what happened, making sure to have thoughtful conversations about whether or not this is a type of investigation that you want to be protected and privileged so that OSHA cannot get their hands on it. And quite frankly, longer down the road, if the horrible circumstance happens that there's a wrongful death lawsuit out there, you don't want something like that subject to discovery in a potential lawsuit against the company years down the road.
So let's talk about that, because sometimes we use terms. I do this all the time that I just assume everyone knows because I use them pretty routinely in our practice, right? So let's say we've had a serious incident. You and I have worked serious injuries and fatalities together. And one aspect, we're trying to secure the scene. We're trying to make sure that no one else gets hurt, and we're trying to get care for the injured. That's the legal obligation, and it's the moral obligation. My number one responsibility as an employer is to take care of my employees. But after that, we're going to be in a process, right? So let's just kind of go through a scenario. We have a fatality. The first call to OSHA has to happen within 8 hours of that fatality. Everything that happens that's not under the direction of an attorney is discoverable to OSHA and to others that may file suit outside of the legal aspects of occupational safety and health. So that word discoverable, can we define that for our listeners? What does that mean to a safety professional, to an executive maybe listening in that's not familiar with the legal process?
You bet. And I want to take one step back before I address that question specifically. Is what is the attorney-client privilege, and how do you go about setting that up? And especially as it relates to using safety professionals. And so a critical piece of that is making sure that investigations are done at the direction of counsel. And so the typical scenario is that a law firm would specifically retain a third-party safety consultant like yourself, James and Dr. Martin, in order to perform the investigation. And so the investigation documentation that you prepare, potentially pictures that you take, are subject to the attorney-client privilege and work product protection because it's done at the direction of counsel. And so that's really what the setup is that we want to have at the base of this piece. And then what is discoverable, I think, James, was your second question. And so let's just say that there is no attorney-client privilege that is attached to the relationship between the parties. If you don't have that specific relationship, whatever you do and say and speak, and whoever you speak with, may be subject to discovery. And what that means is it may have to be provided to OSHA. In a wrongful death lawsuit, you may have to provide it to plaintiff's counsel. And so all the documentation, decisions that are made, anything written, conversations, if that attorney-client privilege has not attached, there's very limited ways in which you can prevent federal agencies, state agencies, if you're in a state plan, state, or for other lawsuits with other lawyers seeking to gain access to that information.
But let me ask this.
Go ahead.
Texts, emails, notes, reports, anything written, right? I mean, we're not just talking, stuff
You're absolutely right, Dr. Martin. And I think this is a key piece that we have to make sure that we emphasize, because text message is now viewed as the informal way to communicate. And so a lot of folks will think, well, that's not formal communication. Or, if I just send a text message to someone, that's not discoverable because it's just an informal way of communicating with people. Every single lawsuit that I am involved in asks for documents and specifically says text messages, written notes, emails. And so anything you put on paper, written or digitally, those are the types of things that they can ask for and that they're entitled to. So your point, Dr. Martin, is spot on here. Is your text messages, watch what you say, pick up the phone call, pick up a phone sometimes. That's the best recommendation in some circumstances is pick up the phone. You may not have a paper trail if that's the circumstance.
So typically in your experience, we've all sort of put out there, it's better to get you involved or counsel involved early on in any type of serious injury or fatality incident, which is always going to involve OSHA in some capacity, most likely, and potentially could involve litigation on the civil side in a negligence claim or a wrongful death situation. So it's always better to get you involved ahead of time. Most companies that experience that, the time is very short to make a lot of decisions. What do you recommend for companies and safety professionals to do in proactive means to prepare for probably the worst day of our lives?
And I think the key piece in this, James, is if you do not have a plan in place of what do we do when a fatality happens, what do we do when OSHA knocks on our door, this is going to be quite a scramble. And so my recommendation is you need to have process procedures in place about what do we do when a serious injury happens, and both of what do we do when OSHA shows up on our door. Having that process in place, and absolutely critical as a part of this process is, have you trained your employees on what to do under these circumstances? You can have the best policies, you can have the best procedures in the world, but if your employees don't know about it, and that goes from the CEO of your business to anyone answering phone calls, someone answering the door, quite frankly, because the first person that probably talks to the OSHA inspector is the person that answers the door, right? Have you trained that individual of what you do under the circumstances of when OSHA calls? Do you tell them to, hey, here's a conference room that you can go in? Who do you call? Do you call the CEO, the safety manager, the plant manager? Having those types of procedures and policies in place and training those folks on that is absolutely critical to making sure that there's no missteps at the outset of an investigation.
All right. So we're going to get a couple more topics, but trying to educate and inform safety professionals, because we have a lot of things to do as safety professionals, and most of them are focused on hazard mitigation and controls and preventing these type of incidents from occurring. But on the rare occasions that they do occur, do you recommend that safety professionals download the OSHA Field Operations Manual and become familiar with it, the chapters that are applicable to them?
Absolutely. And I think a critical part of, if you are a safety professional and you're in the world where you are assisting clients or companies with respect to investigations or fatalities, having a good background knowledge of that is absolutely critical, because if you don't, you may unintentionally be making some missteps, where if you read the manual, understand it, and have a good baseline, that's absolutely critical for the services that you're providing to either the business that you work for or the customer that you're representing.
So I'll add in here, and I know you both know this, but for the people who are listening, it's not just about what happens first, what happens second, what happens third, what happens fourth, right? It also has to do with the rules, because there's rules of engagement and the rules that have to be followed in those steps, right? What is said in those steps, how things transpire in those steps, what OSHA inspectors can and cannot do, what they must do, right? And so it's almost like a rule. The FOM has procedural rules that are really important, because if they don't follow them, then there are issues. If we don't follow them, there are issues. I mean, is that a correct statement, or am I a little off there?
No, I think you're right. I think you're right on. Absolutely. And I think a critical piece is, when OSHA shows up at your door, it's not a free for all. OSHA has limitations just like we do, and they need to comply with their manual, and then they need to do what they say they're going to do, or else there's going to be issues if they don't. Same thing on the other end. If you don't provide OSHA with the documents you're required to provide, or otherwise, there's going to be issues on the back end. So it is a give and take. And from my experience, generally, OSHA inspectors know what they're doing. They've been doing it a long time, and they know what the ins and outs of that manual are, and they do what's within the manual.
Right. So should you, right?
So, well, I think this is one of the things that you just said that kind of highlights why you need to get counsel involved in early. Safety professionals need to do what safety professionals do, and let the attorneys do what the attorneys do. As a safety professional, sometimes we're over willing to share, and we expand the scope of the investigation, or potentially can expand the scope of the investigation. For example, if we have an incident involving like a tag out, and they say, send me all your safety policies and procedures. Well, we're real proud of our safety policies and procedures. We want OSHA to know we have all these safety policies and procedures, and we train on all these things. The next thing you know, we send them 42,000 pages of documentation. And now OSHA's got all these new areas they can look at, where if we just had counsel to say we object to that, we're going to send you what's relevant to this case, things could be a lot easier and a lot better. I don't think it's immoral, unethical as a safety professional to exert the rights of the company. The company has rights. We're going to take care of the employees. We're going to make sure that any type of situation where someone's hurt, or God forbid someone's killed, we've got mechanisms to take care of the families and et cetera. But it's not, those two situations of taking care of the company and taking care of the family are not diametrically opposed to each other. We can do both at the same time. So I appreciate your comments about that. And I want to shift focus just a little bit to some of the hot button topics in occupational safety and health. And I like to call this, my zero tolerance policy is up in smoke. It's gone. Okay. So back years ago, when me and Dr. Martin first got in this, and she's been practicing longer than I have, just about every company that we represented had a zero tolerance policy that said you will be drug and alcohol free in the workplace. If you have an incident, we're going to drug test you. And if any drugs or alcohol is found in your system, you're gone. Is that the same situation it is today, Brent?
To your point, James, it is now up in smoke. We have had so much legislation throughout the country that has legalized either medical cannabis or recreational cannabis. In my home state in Minnesota, our legislature just passed a recreational cannabis bill legalizing recreational marijuana. Before, it was simply medical marijuana that you could use, and now it has expanded to recreational marijuana, and we have seen other legislatures continue along the same path of legalizing recreational marijuana. And every state is different and a little bit different, but I think as we have the legislative winds, so to speak, have started to tell the story on what it is going to look like from my perspective in the years to come. And I think the years to come are going to show us that more and more, whether you're a red state or a blue state, historically, I think the recreational marijuana will become more of a commonplace in the states.
So from a policy standpoint, I've heard people say this, and I'd like you to comment on it, but it's still illegal at the federal level. So since it's illegal at the federal level, I'll just go by federal law and I'll ban it throughout my organization, even in situations that are not safety sensitive. And we'll come back to what safety sensitive is here in a moment. But what do you think about standing up behind federal law as a policy?
I like the statement and I like the premise, but there's challenges on a state by state basis, where if you're relying on federal law, there's going to be some potential issues for you in addressing lawsuits, because there's a lot of state laws that are more specific than what federal law states. And there's been a handful of court cases that have sided with state law over federal law. And that's not to say that there's other federal regulatory schemes that there may be some other arguments that you may have as to the enforcement of federal drug enforcement programs, but we're talking about specifically whether or not federal law trumps state law, and that's not always the case, just based on the case law that we've seen throughout the country.
So, being in the oil and gas industry, a lot of times we'll come back and we'll say, well, safety sensitive position, you must be drug and alcohol free. For example, in jobs that deal with truck driving, Department of Transportation, PHMSA, drug and alcohol free. And they've got specific amounts that are allowed to be tested for and you to have within your system. Outside those specified job descriptions, is every job safety sensitive?
And a lot of these, generally, there's going to have to be an individualized assessment as to what is a safety sensitive job. And that's going to be a combination of what does your state law say is a safety sensitive position? And then from a practical standpoint is what does your job description say about these individuals' particular tasks that they do? Are they safety sensitive? And then that's not the end of the assessment. It's then looking at what do these individuals actually do, right? And just because it's in a job description does not necessarily mean that they are engaging in safety sensitive activities for their job. So it's not an easy yes or a no. It's a particular assessment, and it's an individualized assessment based on job classifications and their work responsibilities.
So I love where this conversation is going, because James knows that my favorite thing to say is it just depends, right? And from what you just said, Brent, it's highly subjective, right? Highly subjective. It's open to some robust argument, right, of what safety. I mean, unless you tell me that a lot of states have actually defined safety sensitive within their laws and regulatory structure. My guess is that this is an argument that happens a lot in court. Like, you can go one way or the other. It's just whoever makes the best argument, right?
And there's a lot of states that have defined what safety sensitive is, but then there's the gray area and the gray space of sometimes the state statutory definition of safety sensitive is not all that helpful. And
Right.
and so you're bound to what does this particular judge believe, or with all the evidence that he or she has heard, are they a safety sensitive individual or not? So you're absolutely right, Dr. Martin, that this is a gray space. And you took the words right out of my mouth. As lawyers, we always like to say it depends, right? And
I
so that's
love
a
it.
frustrating response, but sometimes it just depends.
I love it. You are my new best friend, Brent.
She says that all the time. It just depends. It just depends. The best non-answer answer of all time, right? But it does just depend. And I also think for organizations that work in multi-state environments, it's going to really just depend. Now, from the aspect of marijuana, because that's really what we're talking about. There's not a court in the land that'll let you come to work impaired to the point that you're a risk to yourself, to the employer, to other people. There's not a court in the land. But what has arisen, it seems, is the fact that marijuana stays in your system long after you're impaired. And many people under zero tolerance policies were terminated, even though the fact they have marijuana in their system may not have been a causal factor in the incident they were involved in. And the court seems to be siding with the employees in these gray area and non-safety sensitive positions and saying, hey, what people do in their own home, in their own life, is none of the employer's business. So here's the question. Do you recommend that we define safety system sensitive positions very narrowly? or not?
And I think, and again, Dr. Martin, I'm going to use your favorite phrase. I think it depends. I think that it's going to depend on what the organization does and what these individuals do and how you're defining safety sensitive. If you're going to define it narrowly, then that's a risk tolerance type of analysis that businesses are going to have to engage in on whether or not they're going to potentially risk a lawsuit and the justification is we want to make sure that our employees are safe when they're there at work and that they're going to come home and come back the next day. And that's the risk tolerance that this particular business is going to take. Some businesses want to try to avoid lawsuits, and the way that they're doing that is to not test for marijuana on pre-application and for randoms and only for reasonable suspicion type of testing as well. And I see a lot of organizations that are deciding from a management standpoint that the least risky option is to only test for marijuana when there's a reasonable suspicion or a reasonable suspicion post-accident type of test where they can trigger or say your consumption of marijuana was a causal factor in this incident.
So just so we're clear, just because you have marijuana in your system post-incident does not necessarily mean you were impaired by marijuana during the incident. Would a company under the old way of doing things back in the day, let me rephrase the question. The old ways of doing things 20 years ago, before the legalization of marijuana at the state level as either medical or recreational or whatever, back then, if a employee had an incident and they were tested positive for marijuana and the required drug test to be given post-incident, they would be gone. So What do you think of drug testing people post-incident 100% of the time without evidence necessarily of impairment or reasonable suspicion?
So I think that there is, again, there are some companies that have a policy that says if there is an accident, we are testing you. And you have a lot of state law implications when it comes to conducting that test. A lot of states have what's called a lawful consumable products law, which effectively says something to the effect of you can consume lawful consumable products on your own time, and you cannot be discriminated against for your lawful consumption of those. A lot of statutes have amended those lawful consumption laws to include consumption of marijuana on a recreational basis. And so to the extent that employers are testing on a post-accident test with no reasonable suspicion, there may be circumstances where employers could potentially run afoul of the lawful consumable products law that may apply to those folks. And so there's a ton of state law issues of when you are testing someone and the basis for which you're testing someone that you need to be aware of before you decide to take any type of adverse action or any action against an employee for that matter.
So I'm learning a ton. I'm learning a ton here. You're educating me, which I always love. James, every time I talk to James, he educates me. I'm going to look up these lawful consumable products laws because I think it would be interesting to know those in the states that we have clients in, James, right? Because it's germane. It makes a difference when you're putting policy together, you're advising people. And here again is where you get your attorney involved that knows something about laws in that state.
I think that's the bottom line is in this, trying to create a policy that covers every scenario and eventuality is something that's probably beyond the abilities of most safety professionals to do without the advice of qualified HR and legal professionals. No one wants to be the test case, right? For the case of first impression, so to speak, before the court. running afoul of these laws. But we all see the numbers. We know what's going on. There's a dispensary everywhere now. A lot of states is recreational. You got medicinal. You got these consumable products that's out there. All that's in the environment. But as a safety professional, you still cannot come to work impaired. Marijuana, heroin, cocaine, you stayed up way late and you're not fit for duty, you cannot come to work impaired. There's not a court in the land that's going to say I can come to work intoxicated. Alcohol is a legal product, but I can't show up drunk. Marijuana may be a legal product. I can't show up high either. But I think the challenge is we've had these quote unquote zero tolerance policies for many years. And we all know how the body metabolizes alcohol versus how the body metabolizes marijuana. So, a lot of really good discussions about that. A lot of conferences, they're talking about this all the time. It's ever changing. And so I would say to reach out to attorneys and HR professionals like yourself, Ogletree and Deacons, whatever law firm you use to help craft a policy. Now, let's talk about the word we've been using over and over again. Reasonable suspicion. Reasonable is a legal term, right?
Right.
What does reasonable mean?
And you're going to have to look on a state-by-state analysis. There are circumstances where there are statutes that specifically say what is reasonable suspicion and what are the circumstances under which you can test someone for reasonable suspicion testing.
It just depends.
It just depends.
There she comes with that. Look at it. It just depends. And I want to put that out there because what's reasonable to me may be unreasonable to you. We need to determine what the court thinks reasonable is in suspicion. So
what a jury thinks is reasonable.
What do you recommend employers to do to train their workers, their supervisors, their managers on how to be reasonable in determining whether someone's impaired?
And there's a handful of states that require supervisors to be trained as to the specific analysis as to what is reasonable suspicion, what your process looks like. So you may have particular states where you have to be trained on reasonable suspicion protocol. One of the key ways that employers can go about making sure that they have a reasonable suspicion process that isn't unintentionally created where there are potential disparate type of treatments where you're unintentionally treating individuals differently is making sure that you have a reasonable suspicion protocol and a process. And a lot of companies that I work with have reasonable suspicion checklists. And what that reasonable suspicion checklist is, it goes through a laundry list of questions that you're required to fill out of what is this employee doing? What's their position? What did you observe? What did you observe on them, on their face? What's different about them? Are their eyes red? Are they blurring? Is their speech impaired? All of these certain check boxes that you need to check to make sure that your process is consistent as to how you're analyzing reasonable suspicion. There's a lot of checklists that require employers to have more than one employee look at the observations and say, no, this is just Brent. For, some employee may say, Brent looks off, and the other supervisors that says, no, I look at Brent every day. He's weird every day. This is just him, right? And so they're making sure that your process is robust and you're training your supervisors to do it the same way every time. If you have circumstances where supervisors are not filling out a checklist when they're supposed to, when they're not having a second person look at it, you're creating potential disparate treatment claims where a former employee can say, I'm in a protected class and your drug test was different and you applied it differently to me than you did to others. And so making sure from a training standpoint, you have a robust reasonable suspicion protocol, and that employees and supervisors are trained on how to make sure that they're doing it consistently and in a manner that prevents these types of claims.
Good. That's good stuff
I
right
think
there.
we're going to have you come back for another episode, Brent. I love these conversations a lot. Man, I love you setting me up for that ringer. It depends.
It
It
depends.
depends.
Tee it
All
up.
right. Last topic, and then we'll wrap it up. And it's one that comes up in every situation where we have an employee injured to where OSHA makes an inspection and issues citation. Safety professionals say we trained them, we told them what the rule was, we do site inspections, but we still got a citation and we're still having to pay. Let's talk about employee misconduct defense. Okay. What the elements are so that we can go out there and exert these when needed. Now, I want to say this at the preface of this. James hates blaming the worker. 97% of the time, the worker, in Dr. Reason's quotation, and I can't quote him exactly, but he says the worker is the final garnish to a lethal brew that's been long in the cooking. That it's usually management procedures and training and resources and all these other things that lead up to these serious injuries and fatalities. But Dr. Martin and I have talked about this on earlier episodes. Sometimes you can have people, despite all the training, all the barriers, all the things that go into this, into a safety management system that still violate our policies and procedures. And the company ends up receiving citations for it. So what are the elements that you have to meet in order to exert an employee misconduct defense to OSHA?
And I agree with you, James. I think this is most commonly what I hear on a serious fatality or a serious injury is the employee, unfortunately, the employee knew better and did it anyways. And that's effectively what is called the unpreventable employee misconduct defense. And what you're required to establish in the unpreventable employee misconduct defense is it's the employer's burden to say that you have a policy that addresses it, you've trained your employees on it, and the employer takes active steps to enforce that policy. And most importantly, that I see where employers lack is employers are disciplining individuals and employees at their facilities for such conduct. A lot of times I see that the first 1, 2, 3 elements can be met because generally you're going to have policies that address these types of things. Employers do a good job training their employees, and employees are doing a good job with their JSAs or other types of safety audits where they're actively trying to find any type of violations of policies. But the key piece is, what are you doing when you identify policy violations? And OSHA has told me time and time again, if it's not written down, it didn't happen. And so from a disciplinary standpoint, what are you doing to document your discipline? And in particular, a lot of employees that I initially say, well, when have you disciplined your employees? Well, they'll say, well, we did not necessarily have our first step of written documentation, then our second final step of written documentation, and then a third final termination documentation. That's not necessarily what discipline is all the time. Discipline can be, I told James to put his PPE on, and I wrote it down on my iPad, and it's written down in my notes for the day. That is discipline. And so the day-to-day discipline is absolutely critical to that type of defense. And I'm interested to throw it back to James and Dr. Martin about what you see as a safety professional, the key pieces from the unpreventable employee misconduct defenses that you see there being holes and what you can do to kind of fill those holes.
Oh man. So yes,
It
yes to
just
number 4.
depends.
It just depends. But I will say this, and this is a whole nother conversation, right? It's when to document and when not to document, right? We talked about earlier about what not to document, right? Or what to document under attorney-client privilege, but documentation, the right type, the right the right timing. You can't go back and recreate a discipline event, okay? It has to be like you said in your notes on the date. You can't go back and rework your training documentation to reflect something that's not there. You can't go back and change a policy that you never had, or right. So I'm going to say it's everywhere, right? And it's in the documentation, and it's in the actual application of all those 4 elements. It's all 4. It's all 4.
I will agree with that, and I would say that there's some more than others in those elements. Most people have policies. Now, whether those policies are good or not, you can contact me for an assessment, and I will tell you whether your policies are good or not, right? Okay? No, not really. Most people have some gaps in the written programs and some gaps in their training. In nearly every assessment I've done, there are gaps in their policies, there are gaps in their training. The going forth to discover hazards and is somewhat the same as looking for compliance with the safety management system, right? So our safety management system is supposed to be identifying hazards, putting controls in place, and some of those controls can be things like PPE. Going out and telling someone, hey, Dr. Martin, you're not wearing your hard hat, you need to put your hard hat on, is a form of discipline. Most people are not documenting that. Most good companies that aren't having a lot of workplace injuries and accidents don't have a lot of disciplinary issues in mature safety management systems. But that doesn't mean bad things can't happen to good companies. So document that. Here's how we document it at Mariner Golf. As my guys go and ladies in the field go around and do site inspections, what they find is documented in their written daily report that is kept by day and by site, by location, and by person. Now, here's the number 2 most common discipline I see: retraining. Retraining. Brent violates some rule. He's not wearing his fall protection. So what do? We bring Brent in and we retrain him. Is that a form of discipline? Yes. If it's documented, it's there, right? So that last element, discipline. Nearly every company has a disciplinary policy, but not every company's following that policy. I don't know that I've seen more than a handful of companies that have been able to, that tried to exert the unpreventable employee misconduct defense in my practice, that it's been successful. It's failed because they don't have documentation of the discipline. So that's my comments to your question.
You agree with Brent?
I agree with Brent.
And with me.
And
with everybody.
Yeah. With everybody. So how do we go forth, Brent? In closing this out, we appreciate your time. We know you're extremely busy, and it's been great. This episode will get a lot of views and a lot of discussion. That's why we wanted to have you on. But a piece of advice: if you could offer one piece of advice for safety professionals that are practicing today, what would it be?
And I'm going to state the obvious here, but time and time again, you go back to documents. What do you have in your documentation? And I think the absolutely critical piece when I jump into a case is show me the documents you have. You need to make sure as a safety professional that you have the policies in place, that you're doing what your policies say you're doing, that you're documenting the training, that you're putting the date and the time and the signature on the training to make sure that I can verify with OSHA that yes, this individual had their respective training. This was the date. This was the annual recertification. Those types of small details are absolutely critical. So I know this is a big statement of documentation, but making sure that you are adequately and effectively documenting what you do, the controls you have, and making sure that you're dotting the I's and crossing the T's on your documentation. Because again, like Dr. Martin said, you can't go back and fix things. And you need to make sure consistently that you're doing what you say you do and documenting when you do it.
Well, thank you,
Thank
Brent.
you,
I
Brent.
think that's outstanding advice. Thank you again for coming to this episode of the Risk Matrix powered by Veriforce. We are now on Spotify. So if you're watching us there on YouTube, you can also hear us and see us over on Spotify. But if you're on YouTube, smash that like button, hit subscribe, get down in the comments, and let's have a debate about the legal aspects of occupational safety and health. Dr. Martin.
So I just want to say last thing, or ask one last question. Brent, how do they get a hold of you if they want to ask you questions directly?
Please, and thank you for the plug here. And again, my name is Brent, and I'm a shareholder at Ogletree Deacons in our Minneapolis office. You can get a hold of me through email, brent.kettlecamp@ogletree.com, or you can call my office line at 612-336-6850. But thanks you so much, James and Dr. Martin, for having me on. I had a great time, and I love these types of discussions, so I could talk for hours, but
You're coming back, baby. You're coming back to the Matrix. Thank you so much, and thank you everybody else for watching the Risk Matrix and listening to us on Spotify, and we'll see you next time. Roll
We'll see you
Tide.
next time. Y'all keep bringing those workers home safe.